Welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide the information and resources that'll help you to decide whether or not you want to contact a lawyer. Perhaps will help you to determine that you actually can handle some issues yourself. Either way, our goal, of course, is to help you achieve the best possible results, saving time and saving money. We want to thank from the Bazar and Associates law firm in East Providence, our attorney, David Bazar.
Thank you, Deb.
Thank you, who continues to donate his time and energy and expertise on the various issues that we tackle. So today, jury trials, specifically how they work, the anatomy of them, the process, and your role in it. Perhaps more importantly, at times, the importance of your options. We all know that serving on a jury trial is, at times, an inconvenience, but it's also your civic duty. Sometimes it's an interruption to your daily activity, but often considered to be well worth it. So many think it's a simple task to determine someone's guilt or innocence. It's based on facts and evidence and so forth. How do we get there? Did you know, in fact, that's not your only option, although it's often not discussed. The topic we'll also tackle is jury nullification. But let's start, David, with the basics of a trial by jury versus a bench trial. Go through some of the basics.
So, I think it might have been Sandra Day O'Connor who said something along the lines of having a case resolved in a trial is the end of the case, not the beginning of the dispute resolution, and that you should try all other alternative resolution methods first. We know there's settlement negotiations, there's arbitration, mediation. Now, none of those have worked. You turn to the court to get justice, and that's the last place you want to be sometimes, but it's the final place that you would go. So depending on the type of case you have, it can be a case that's either tried to a jury, and the Constitution gives us certain cases where you have a constitutional right to a trial by jury, or to what they say a bench trial, or to the bench, which is where the judge decides the case. In either instance, if it's a jury trial, the jury's in charge of determining the facts to apply to the case after the judge instructs them on the law. If it's a bench trial, the judge determines both the facts and the law and makes a decision.
Back in the colonial days, or from England, there were more occasions when you had the judge. And I understand that in various states, some have different ways of handling trials. Not all of them are trials by juries. But that's considered to be the best way at times. And when is it considered to be the best way? Jury of your peers?
There are certain types of cases where you're not entitled to have a jury. And in England, they had courts of chancery or equity versus courts of law, so to speak.
Common law, as they
say. And so those things that were tried in equity, which is really, in the United States, types of cases where you're looking for the judge to make an order to resolve a thing rather than money being awarded, such as an injunction or restraining order or that type of thing. Those are equity types of claims that only a judge can decide. Juries don't weigh in on those. So if it's a case being tried at law, so to speak, then you have a right to a jury if it's a criminal charge. And in Rhode Island, if you have a misdemeanor, you have a right to waive the jury in the first instance. But if you lose, you have a right to appeal to have a jury trial in Superior Court. And if it's a felony, automatically out of the gate, it's Superior Court, and you have a right to a jury trial. Both sides can waive, a criminal defendant can waive a jury if they want to. In civil cases, at district court level, there is no jury, there's no right to a trial by jury, but if your case is big enough to bring to the Superior Court, then you have a right in those types of cases to request a jury.
We talk at times about the value of do-it-yourself, looking up things online and being able to handle it. So at what point, I know there's small claims court, maybe you can represent yourself, it's under $2,500, thank you. But beyond that, when it comes to these other kinds of cases that are trial by jury, value of going and representing yourself?
You do not want, people do it sometimes, you do not want to represent yourself in a jury trial. You really don't want to represent yourself in any trial if it's for anything significant, a criminal case or a civil case for a fair amount of money. But certainly in a jury trial, there are too many little nuances and lore and facts and things that you need to know. You don't want to try your own jury trial case.
Okay, so knowing that we're going to have a lawyer, let's go through the anatomy of a jury trial and choosing one, I guess, the jury of your peers.
Right.
Go ahead.
Well, the first thing that usually happens just before a trial in front of a jury is the parties have a right to file what's called a motion in limine, or preliminary motions, which are usually motions addressed to whether or not certain things, pieces of evidence should be excluded from the trial, not mentioned, certain issues maybe with the plaintiff that the plaintiff thinks are irrelevant and are more prejudicial than probative, and the defense shouldn't be allowed to raise it. Other types of evidence of whether or not an expert's opinion should be allowed to be brought in. Those are types of things that usually can be handled preliminarily before you pick the jury. But once all those things are decided, then it's time to pick a jury, and you could make a movie or a TV show about picking juries.
Interestingly enough, and there are some.
There are.
Prime time,
Okay.
in fact.
All right. So picking a jury is somewhat of a science, as some of these experts at jury selection will tell you. And there's a process to it. You first start with what's called voir dire. And that's where you, as the lawyers, are allowed, and depends on the judge how that process works. There are different nuances that different judges use, where the judge will ask most of the questions and allow the attorneys to ask some or submit some, or some judges, it's free reign. The attorneys ask most of the questions. But you want to ask questions to the potential jurors as to bias, types of claims they may have had, other situations they've been involved in the jury system and trials, and loved ones, and just generally what kind of person they are. And that's where these experts will tell you that some people are more likely to award money to someone and other people less likely. And what type of case you have might influence the type of juror you want. So there's a lot of factors that go into that selection.
With your experience, David, have you found that either you have challenged or the opposition has challenged someone's ideological predispositions to something based on a simple question that was given? Do you find that you've had to challenge that very often?
In every state and federally, there are slight differences as to what types of challenges, or how many challenges really that you have and how you exercise those. So in selecting a jury, there are challenges for cause, which are you need to raise this challenge with a judge because somebody has either so much prejudice against your case or your client, or interest or bias to it, that they can't sit. And then there are other challenges you get just as a matter of right. And so you can exercise a certain number of challenges based on your right to just say, that person doesn't sit well with me. I don't like how they answered some of those questions, where the challenge for cause wouldn't necessarily hold up. You have the right to challenge a certain number of jurors and just say, yep, juror number 10 is struck.
And if who has the ultimate say as to whether or not a juror is acceptable?
Well, there's, like I said, challenges for cause.
Yes.
The judge has the ultimate say.
Judge does. Okay.
Then there's those challenges that you get just to make a certain number as you're picking your jury. The guy in your earphone, your expert that you hired, is saying, juror number 4 is not going to be good for your case. Just strike juror number 4. Okay. And you have the right to a certain number of those preemptive challenges.
Okay. Next in the anatomy of a trial?
Next, we've now seated the jury. Mm-hmm. The jury is instructed on the case a little bit by the judge, and then there's opening statements. So if we're going to do a civil trial, the plaintiff goes first, and the plaintiff has the burden of proof, so they're the first one to speak to the jury. And you, in your opening statement, really want to lay out the case to the jury, what you expect to be able to prove. You don't make an argument at opening statement. So if you want to say certain things, don't say to the judge when there's a preliminary motion, I want to argue something, because the judge say, no one's arguing anything in my courtroom, but you can refer to what this witness might say or what that witness might say. But what you really want to do as a lawyer is paint a picture. And you want them to buy into your case right from the very beginning. The defense in a civil case has the right to open right after you, as the plaintiff, do, or they can reserve their right to open. Most defense lawyers don't want just the plaintiff's voice to be out there, so they'll open at that time usually as well.
When might there be a time when you would not have an opening statement at the opening of a trial?
Usually you would. If it's a bench trial and the judge is well versed in all of the issues, you might not do an opening statement then. But with the jury trial, as far as the plaintiff goes, you always give the opening statement at the very beginning, because you want them to understand what they're going to hear and what the evidence is going to show.
Interestingly, in preparing for this, I had read a couple of notes about how the prosecutor will be, in his opening statement, presenting the facts that will be presented in the case. And then on the other side, the defense gives an interpretation of the facts that will be
well,
as if one has the sole judgment and understanding of what the facts are, and the others is an interpretation. It seems slightly...
And you said prosecutor.
Yes.
So that would infer a criminal trial.
Yes, okay.
And in a criminal trial, the defendant has, and really in a civil trial too, but especially in a criminal trial, the defendant has no obligation to present any evidence. So
good to know.
What you're referring to is the defendant's lawyer is saying to the jury, basically what you're saying is, this is the evidence they're going to present, and you can't argue what the evidence is, but you can sort of slant an argument, if you will, towards the interpretation of what that evidence is. And basically you could say they're not going to be able to meet their burden of proof, and as a defense lawyer you want to hammer home that it's the prosecutor's burden of proof, and they're not going to be able to meet their burden of proof because the evidence they're going to present isn't sufficient to do that. That's almost an argument,
yes.
But like I said, you don't have to get up and say, and we're going to present so and so and so and so and so and so, because you don't have that duty. Now you could say our experts. The defense will present experts too, who will dispute what the prosecution's experts are going to say.
Okay, so opening statements have been made. How does the rest of the trial play out, David?
So now, civil trial, I'm back to a civil trial.
Yes.
The plaintiffs start calling witnesses to present evidence, and evidence can come in a lot of different forms. So most of the evidence is testimonial evidence. You solicit through direct testimony the evidence you want to present to the jury through your witnesses. So if we have an auto accident claim, you might have the plaintiff testifying as to how the accident happened, how they were affected by the accident, what medical treatment they had, what work they used to do, what work they can't do anymore, those types of things. And then you might want to present your medical doctors to testify to the treatment they had to do. If there were surgery, you would like them to put up some kind of graphic or evidentiary, demonstrative evidence of what the surgery was, so the jury has a good understanding of what the plaintiff went through. And you might submit the medical records so the jury has a chance to review those, the medical bills, lost wage statement, or a subpoena of records. So the records are evidence. They're put in as what we would call exhibits. That's the documentary evidence. Photos might go in, documentary evidence, physical evidence. In a criminal trial, there's always a lot of physical evidence that's going in. So all of those exhibits are marked. Usually start by marking them for identification, and then after you've proven that they're a reliable document or a piece of evidence that should be accepted in full, then it goes in full and the jury's allowed to see it. A lot of times when I'm talking to attorneys who are doing these trials, if you have a diagram, for example, and you want the expert to testify to it, you might want to blow that diagram up or at least have copies of it that you can publish to the jury so that they have the opportunity to follow along with what the witness is testifying to. Then a lot of times what you might do is if you have a document that you want the jury to see, but they don't need to see it right away, you might ask to publish it to the jury right before you finish your direct examination. So they're looking at it when the defense lawyer is starting his cross-examination, so they might be a little distracted by what is coming next. But after direct examination, the defense lawyer has the right to cross-examination. And of course, the difference is in direct examination, you're asking someone to tell the story. In cross-examination, you're picking apart the story. So you're allowed to ask leading questions. And most of your questions on cross-examination usually would be questions that sort of close the door to where you want to bring the witness. Isn't it true that? Isn't this the case? It's really questions where you're telling them what the answer is. That's what a leading question is. And you're telling them the answer that you want them to testify to. So you're trying to narrow their responses.
So in your process of poking holes, as it were, or leading, you certainly know what is considered to be objectionable. Mm-hmm. Doesn't mean that you wouldn't get it out there anyway. No, and do you? Knowing full well that your opposition is going to object to it, they're going to sustain it, someone's going to tell the jury you'll disregard it, but right. Point final, it's already out there, and is that right. Its own purpose? Sometimes if the witness has already testified to it and it's objectionable and they move to strike and the judge tells the jury to disregard what the witness said, it's how do you unring the bell sometimes. So oftentimes I tell lawyers who are trying cases that, number one, object. And the judge has to now do some work in this case, and that's what the judge's role is, to determine what evidence the jury should hear and what evidence really the jury shouldn't hear. And there are a lot of rules of evidence. So one of the common ones, just by way of example, that can be argued many different ways, is hearsay. So what is hearsay? Hearsay is an out-of-court statement that's being presented for the truth of what the statement was. And I've been working actually with some mock trial students judging their mock trials. And in this particular case, the witness on the scene says something that is damaging to the defendant's case, and it's a criminal case in this case. And so the one side stands up and says, objection, hearsay. Now, there are exceptions to the hearsay rule, and so the other side might argue it's an excited utterance, so it's an exception to that rule. Now, they can go back and forth, and the question is, well, when was this excited utterance made? Was it right after the accident, in which case it might be an excited utterance, or you might argue that no, it was made to the police officer who didn't come to the scene until sometime later, attended to some other people, and then came over, and then the utterance was made. Well, the judge has to determine whether or not it falls under the exception or not. Interesting. Interesting nuance. Yeah. And there's a lot of rules like that. That's why it's not a do-it-yourself job. Good point. Point well made. So you've gone through testimony, cross, redirect. What right. next? So after the plaintiff or the prosecution, if it's a criminal case, has presented all of their evidence, they rest. And in a criminal case, the defendant might move for a directed verdict or verdict, of acquittal, depending on the state, what they call it. But it's basically a motion to the judge before you present your case saying, state didn't prove its case. There's no evidence beyond a reasonable doubt, or any likelihood of that the jury could rest a verdict on, so you, as a matter of law, should dismiss it. In a civil case, same type of motion, the burden of proof, which is not beyond reasonable doubt, but a much lower burden of proof, you just say the plaintiff didn't meet his or her burden of proof, the case should be dismissed, a directed verdict, and you're asking the judge to dismiss the case before you have to start. Does that happen often, David? Not in civil cases a lot, because if you made it to that point already, usually there's enough to get to a jury.
And so the defense will then present its case. In criminal cases, the higher burden of proof, many times, the judge, not many times, but the judge could find that that's a higher burden of proof. The prosecution didn't meet that burden. In both cases, the judge has to take whatever evidence has been brought in and look at it in the light most favorable to the plaintiff or the prosecution in determining whether or not they met their burden of proof. And if in a plaintiff's case, you look at the evidence that the plaintiff presented in a civil case in the light most favorable to the plaintiff, oftentimes it's really difficult to find that there's not at least something that the jury can't hang its hat on in finding for the plaintiff.
Okay. And next, after there's been
Both sides
well,
the
rest,
plaintiff has rested. Now the defendant has to present its case, and it's the same thing sort of in reverse. The defense now calls their witnesses and puts in their documentary evidence and their exhibits, and they go on direct, and the plaintiff's lawyer or the prosecution is cross-examining the witnesses. And so it's the same thing, so we don't have to go through, those steps again, but they have the same right to present their case just as the plaintiff or the state did.
Okay. And then?
Both sides rest.
Both sides rest.
So now both sides have rested. What you're going to ask comes next.
Argument, yes?
Now, yes. So there again can be some motions.
Okay.
Okay.
Such as?
Well, again, I want to renew my motion for dismissal, blah, blah, blah.
Okay.
Those types of things. But usually, you're right, what comes next is closing argument. And in a civil case, the defense goes first, and then the plaintiff, because the plaintiff has the burden of proof, so they get the last word. And in a criminal case, the defendant's lawyer, and then the prosecution, because they have the burden of proof. Is that right? I have to think about that one. But definitely, I'm pretty sure. Yeah, and definitely in the civil case, the plaintiff with the burden of proof goes first, and then goes last.
Goes last.
Did I say last?
First, then last. So
no, it's
restate,
last.
Restate, Counselor.
Prosecution, plaintiff, last, because they have the burden of proof. So they get the last word. I think I did say that.
Yes, I think you did too. Yes.
Okay.
So the closing arguments are made. One saying, we've proved it. The defense is saying, no, you didn't, and here's why,
Right.
however that goes.
Yep.
Now it's close to the time that the jury has its call. So what's happening next? The judge is
giving instructions.
Which is what, David?
Yeah. So, some judges actually do it a little differently. Most judges, I believe, most judges still do, give instructions after the legal arguments, after the closing arguments are made.
Yes.
And again, the closing arguments are a summary of what's been said, and you want to point out the evidence to the jury that you want the jury to really listen to and take back into that room with them when they deliberate, and you really want to look at what this expert said versus that expert, and this expert was biased, and this is why that expert was biased. And now it's argument on close, because you can really tell the jury what you think the evidence shows. So it's your argument to them as to how they should look at it, as opposed to the opening statement with it just, this is what it will show.
What will show.
Okay. So you can characterize the bias of a witness. You can emphasize the importance of the doctor who was the treating physician who saw the patient every day versus the insurance company. Well, you can't have insurance. You can't say insurance to the jury. They're not allowed to know there's insurance. But the doctor who examined the patient for the defendant or one time, or who reviewed records and never saw the patient. So you can make those kinds of arguments to the jury. Then the judge, usually at that point, will instruct the jury on the law, the burden of proof, all of the general things that a jury needs to know going in. What is circumstantial evidence versus direct evidence? Because a lot of time cases might turn on circumstantial evidence, and it's just as valuable as direct evidence, but what is it? So the instruction a judge often gives on circumstantial evidence is, if you went to bed and there was no snow on the ground, and then you woke up and there was snow on the ground, you can infer, based on those two facts, that it snowed during the night. You didn't see it snow. Direct evidence would be, I walked out in the middle of the night and I saw the snow coming down, I know it snowed. Circumstantial evidence is, I didn't see it snow, but there was no snow when I went to bed, and when I woke up there was snow. So that's the type of explanation of circumstantial evidence a judge might give. But then they'll give instructions on the law that's pertinent to the charges in a criminal case or the claim that the plaintiff is making in a civil case.
So we know that the next thing that's going to happen is the jury is going to deliberate, come up with a verdict. But before this happens, while the judge is giving its instruction, we know that there is such a thing, and we're going to let you define it, as jury nullification. It has become a contentious issue. Not that the jury doesn't have the power of jury nullification, but how it gets explained to them, and it often not even mentioned. We understand jury of your peers, they could have sympathies, they could have proclivities, they could just say that law isn't right, and a judge is going to say, here's the law. Where does jury nullification come in, and why is it so contentious?
A judge has the job of explaining the law. The judge doesn't have the right to say, if you don't like this law, you can ignore it, because the legislature makes the law and the governor signs that law into, those bills into law. So most judges, almost all judges, are not going to instruct a jury that they have a right to ignore the law. They're going to instruct the jury that they have to follow the law. Now, what a jury can do in following the law is sort of the same thing as jury nullification. If they really find in their argument in the back room that they don't like it, they are, especially in a criminal case, they're not likely to convict somebody. They'll find someone, their jury nullification many times is done on the basis of finding someone not guilty. I don't like the law. Well, the judge told us we have to follow the law. I know we have to follow the law. I don't think he violated it then. So I'm going to find him not guilty or her not guilty.
So in earlier times, two classic cases that come up, one was about slavery and the other was prohibition. We know what the law was. However, by the time the jury have had sundry cases to look at, they may proclaim that ain't right,
right,
or just say, I'm not going to incarcerate that person or whatever.
Right.
So it's very interesting that they do have that power. A well-informed person might know that they have that power
right,
and that right, but they can't rely on the judge giving them the charge to also factor that in,
right,
which is unfortunate. So if you're not well-informed, and I know that there's some FIJA, some jury affidavit that lets them know, but how many people are going to do that?
Right.
But the point I think about some of this is that there are times that maybe jury nullification and that power that a jury has, they have the right, they should have the right to know and be informed in case they aren't.
Right. So, and you're right, except that it's sort of a separation of powers issues. So the judge just wants to do what the judge is supposed to do. But if a judge really doesn't like a law, perhaps if it's slavery or prohibition or whatever, they're not going to tell the jury you have a right to ignore the law, but how they give the instruction might be slanted. And certainly when the jury goes in the back and they have their discussion, that jury's going to discuss the law if they don't like it. And so while they're not being instructed that they have a right to ignore the law, that might be exactly what happens sometimes.
Good point, and you can have the last word. We thank you for tuning into The Law Matters, because as we tell you, the law matters to you.